Hi, I'm attorney Gary Finklea from the Finklea Law Firm in Florence, South Carolina. I'd like to speak with you regarding some basic issues when entering a residential landlord-tenant lease. First of all, the South Carolina General Assembly has adopted the Residential Landlord Tenant Act. It can be found in Title 27-40-10. That act contains a number of the general provisions in regard to landlord-tenant matters. There are other provisions within this code section as well. When entering a lease, the first thing to be aware of is that if a lease is for less than 1 year, it does not have to be in writing. Of course, that is not the better practice, but just be aware that verbal leases can be enforceable under certain circumstances. Of course, the better practice is to enter into a written lease. Generally, leases contain certain basic information such as the parties, the amount of rent, the term, the property description, what services, appliances, and other extras may be included within the lease agreement, and finally, when payment and where payment is to be made. Now, the lease agreement can be much more detailed than that, but those are some of the basic elements that you see in a lease. Of course, a lot of folks get leases off of the internet that aren't germane to South Carolina and that contain some provisions that do not comply with our law or haven't been blessed by a South Carolina attorney. My suggestion to you is to consult an attorney or realtor to get a residential landlord-tenant lease agreement. The Realtors Association, quite frankly, has one of the best lease agreements that I've seen, and we use in our office those agreements and often tweak them to certain and unique circumstances. There are two things I wish to speak with you about other than just leases in general. And the first is non-payment of rent. In South Carolina, under the Residential Landlord Tenant Agreement, Section 27-40-710, Paren B provides that if you include in your lease agreement a provision in bold letters that is conspicuously stated that you do not have to give the tenant notice to evict for non-payment of rent. The notice itself within your lease agreement should read something along the lines as follows. In the event you are more than 5 days late in making your rent payment, no notice need to be sent to you prior to the landlord taking eviction action. Therefore, that's the only notice you need. That is a provision that is different than many other states and different, or that you won't find on these generic leases you get offline. So that's one provision I wish to speak to you about. The other is, what if the landlord fails to cure any defects with the property? We get a great deal of calls about that. First, if you're a tenant and you have problems with the property you're renting, the law requires that you give the landlord notice in writing. Now, I can't emphasize in writing enough. I'll tell tenants that, and then they say, well, I've given the landlord notice. I've told him or her many times. Well, that's not what the law says. The law says you have to give the landlord notice in writing. Once the landlord is given notice in writing, then the tenant, of course, has other rights under the Landlord Tenant Act, such as to withhold the rent, to fix the problem, and to bill the landlord, or to rescind the rental agreement. The area of landlord-tenant law is broad. There are many issues, and I'll be bringing you more answers and discussions on this topic in the future. But if you have any questions in the meantime, please feel free to contact me at 317-4900 or by email at gfinkley@finkleylaw.com or through our website, finkleylaw.com. Thank you very much.